Judge.
Good morning.
Your Honor, this is a partition action. This is my motion to employ a broker pursuant to TCA 2927-310. Judge Turnbow has already entered an order finding that this is heir property and establishing the value for satisfaction of the partition suit. One of the heirs has filed a bankruptcy petition, so we were subject to the automatic stay. We have now received an order from the bankruptcy court authorizing the listing of the property. We're just asking the court enter an order mirroring those terms, allowing the petitioner to list the property with Mr. Bobby Woods at Keller Williams at 2.5% commission.
Any opposition voiced to this motion? No opposition. Your motion is granted.
Thank you, Judge. I'll draw an order.
All right. But the case that's going to be heard will require testimony, and as a result, if you are going to be a witness for either side in this case, you must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You are prohibited from discussing the testimony of any other witness with anyone or from watching the proceedings which are being live streamed on YouTube, and violation of that order would not only constitute contempt of court, but it would bar you from testifying. All right. If you're a witness, you must go outside. You have witnesses that need to go out.
Judge, I would request the 12-year-old Miss Sophie also. I'm not sure if she's going to be called to testify.
Not testify.
That's
All right.
fine.
So whoever's in this courtroom is not going to be prohibited, is not going to be allowed to testify unless they're a party at this point. So,
Judge, just to clarify, the contempt actions that we filed previously, those have been dealt with. So the only thing that's before the court is basically the final hearing, the establishment of parenting plan. And so I'm hoping that it will not take very long today. And so just a brief procedural history, since this case has been going on since last year. As you've stated, Judge, back in March of 2024, my client has filed a petition for paternity in response to a child support action that was filed against him, where he was ordered to pay $800 per month. In May of 2024, he was confirmed as a biological father following a DNA testing. And then in July 8 of 2024, he filed a motion for a temporary parenting plan on the basis that Ms. Youwit was not being cooperative with visitation time with him. And that was heard August 31st of 2024, where Your Honor ordered supervision at the mother's home. And I believe that this was largely based on the fact that the mother claimed that the child had medical issues, heart conditions, nonverbal autism, and things of that nature. And so you were not comfortable with father having unsupervised visitation at that point. And so father attempted to have visitation from August 31 all the way to November 19 when I was hired in this case. From August to November, father had difficulties with this supervised visitation, resulting in us filing for contempt actions and motion for Christmas visitation. That was heard November 19, and Your Honor did allow my client to have unsupervised visitation overnight. That was for the Christmas time, but kept the same visitation for my client. And that day also, the mother maintained all of her claims that the child had some rare condition. He was going to therapy throughout the week. He was getting speech, OT, ADA, physical therapy. And so based on that, again, my client stayed in that same visitation. And so then we fast forward to January 29. At that time, I had subpoenaed all of the medical records and the TEIS, the Tennessee Early Intervention records. and the school records. And we had a hearing January 2029, resulting from our motion to appoint my client as a temporary parent, primary residential parent. At that point, we were so concerned of what we found. And in that hearing, Judge, you did found that Mrs. Youwit had delayed access to certain services with TEIS for about a year, physical therapy, speech therapy, developmental therapy. There was an ophthalmology consult that was not done for months. Ashton had a cardiology appointment that was not done, well baby checkup, and that's in the order, Judge. And so at that point, Your Honor did not find that Ms. Youwit was credible in her testimony, and you appointed my client as the temporary primary residential parent, and then awarded Ms. Youwit a weekend visitation, and the child support was suspended at that time. February 25 of 2025 of this year, Ms. Youwit then hired an attorney. We had to file a second criminal contempt because at that point, your order was for Ms. Youwit to return the child after her visitation to Mr. Fenton. And by May 14 of 2025, you heard two motions, actually three motions, all of my contempt motions, and Ms. Youwit's motion to reconsider the January 29, 2025 motion. You denied that motion to reconsider, and then you found Ms. Youwit guilty of 2 counts of criminal contempt, specifically. That was 2 days in February where she refused to return the child. And you had suspended the 20 days of incarceration at that point. And then you also, Judge, modified the pickup time from 4 p.m. and my client was supposed to pick up. So that way we prevent, further issues. And then also on that day, we were supposed to be heard on this motion for the permanent parenting plan, but because Your Honor was considering the fact that the lawyer was just hired that time, that you were giving him some time to get acclimated with the case, you continued that, and then here we are today. And so, Judge, our goal is to finalize this case and finalize the parenting plan. And also, Ms. Youwit, obviously, his lawyer had withdrawn by July of 2025. It's been well over the 30-day period that you gave her, so she hasn't hired a lawyer, obviously. We had filed a proposed permanent parenting plan initially, but that has now changed, and so I am going to present amended one just based on the recent events that happened in the interim from May when we were here to today.
That hearing had a little bit of everything. Judge David Wolfe presided over a family law case that had stretched on for more than a year. And by the time the court reconvened, it was clear this wasn't just about paperwork, but about the credibility of the parties and the well-being of a child. Engine began with a quick motion in a partition suit, approving a broker to list inherited property after the bankruptcy court lifted its stay. Judge Wolfe granted it without opposition, then immediately shifted gears, reminding everyone that because testimony would be required in the custody matter, witnesses needed to wait outside the courtroom to preserve fairness. His tone was firm but instructional, even making clear that watching the YouTube live stream would count as a violation of his order. The heart of the session was the custody dispute between Mr. Fenton and Ms. Youwit. The case's history was long. Fenton had first petitioned for paternity in 2024 after being ordered to pay support. DNA confirmed his status, and when he sought visitation, he initially faced only supervised time due to the mother's claims that the child had significant medical and developmental issues. Over time, however, records showed she delayed or missed appointments, cardiology, ophthalmology, therapy sessions, and Judge Wolfe found her less than credible, shifting temporary custody to Fenton in early 2025. Since then, contempt motions had followed, including a finding that Youwit twice refused to return the child, earning her suspended jail time. At this final hearing, Fenton's counsel laid out the case for a permanent parenting plan. His goal was to keep him as the primary residential parent, arguing that the mother's pattern of obstruction and credibility problems made anything else unworkable. Youwit, now without counsel, was left to navigate the process on her own, and the court noted she'd let the 30-day window to retain new representation pass. The judge allowed her to proceed, but made it clear the record showed repeated noncompliance. The atmosphere was serious, at times tense. Fenton was steady, his counsel prepared, while Youwit appeared isolated without an attorney. Judge Wolfe's demeanor blended firmness with patience, insisting on rules, reciting the procedural history in detail, and setting clear expectations that the day's goal was to finalize a permanent plan, not revisit old ground. What stood out most was the judge's insistence on clarity, whether it was separating the partition motion from the custody matter, controlling witnesses, or reminding parties that contempt rulings carried real consequences. It was a reminder of how family law isn't just about parental wishes, but about consistent compliance, credible testimony, and the child's best interests. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I raid everyone.